There, I apologize. So common refusals. Uh, the animal's too loud. The coworker is allergic to emotional support animal. Again, if you know the law and you know these are common, and you can say, well, that, then they need to ask for their own reasonable accommodation. I shouldn't be, it is against the law to do that, period. Creates an indoor indecent odor or offensive to the senses. So the animals have to be clean. That bottom line. The emotional support animal is a dangerous breed. Now, remember, emotional support animals can be any type of animal. So it's probably about 3 years ago, I read an article. A gentleman was moving to a retiree home, and he wanted to take his emotional support animal, which was an alligator. So, think I don't, it just, it was denied, and I don't really have to go into details about it, but just something like that, is pretty obvious. But I'm sure there's other cases that's not so clear. If the animal's too loud, you can propose a humane bark collar or complete an animal training. If the coworker is allergic, just like I said, propose to relocate the employee, get HEPA filters. If it's an odor, you need to verify that the odor is from some other source. If it's true, prove that the emotional support animal is clean, bathed regularly, and odorless. And again, the ESA can be any breed, size, or weight and is not subject to employer limitation. But again, if it's something like an alligator, it's something like a chicken or a duck, things like that, if it's clucking or making too much noise and it cannot be controlled, then those are reasons to deny. So the new laws. So on January 1st, California enacted new emotional support animal laws. And so anyone selling emotional support dogs must provide written notice that the dog does not have the training required to be a service animal. And then when it comes to paraphernalia, anyone selling certifications, IDs, tags, vests, leashes, or harnesses for ESAs must give the same notice. And then for healthcare professionals, requirements to issue emotional support letters, you must hold a valid active license and include the details of this emotional support animal documentation. And you must have an established relationship with the client at least 30 days before issuing the emotional support animal documentation. And then the Air Carrier Access Act, reasonable accommodation only applies to service animals as of January 1st. Emotional support animals may be able to go if they are in a carry-on that would store under your seat, and pets must be small enough to qualify, and a fee is typically charged. To file a complaint, if you feel that you've been discriminated against, you can come file a complaint with the United States Department of Justice or by calling the department. You can also file a complaint with the California Department of Employment and Housing Act. Or you can file a lawsuit with your state